Okay, Assalamualaikum guys.
Salam.
Waalaikumsalam.
Okay.
Thank you for
Yes.
waiting. So we will continue more where we left on the last meeting. So our last meeting we already discussed about the formation of partnership and etc. Today we are going to discuss about the liability of partners together. I know that you guys have done your research, so we will be sharing what we know. Okay, I'm going to start first. From what I have researched these past few days, I have interesting information about contractual liability. There is two categories in it, which are joint liability and several liability. Joint liability is for the living partner. It's where all partners in a firm are liable for all debts and obligations, which are incurred while each is still a partner.
What about if I am no longer a partner and pass away?
Okay, if you are no longer a partner and pass away, then it will fall under the category of several liability, which means that you will still be liable for the debts and obligation that arose while you are still a partner, but you need to settle your separate debts. Then whatever you need enough or not will be used to pay whatever still unpaid. Okay, that's it. What I have learned.
From what I have known under cautious liability, partners may be liable for wrongs committed by their fellow partner independently of any contract. It must be committed partner the ordinary course of business and authority of his co-partner. For example, when one of you bribe a worker in a rival firm to reveal to you some confidential information relating to the firm's rival and the firm suffers loss, they will sue our company for damage. It will held that we were liable for wrongful act as obtaining information. This means that our company is liable if one of us do that.
What about if partners do a criminal act with all the partners affected?
As you guys know, partners are jointly liable in civil cases, but in criminal cases, they are not jointly liable. Criminal liability is a personal liability a partner who commits a crime.
Okay. I have a question. What will happen if there is any misapplication of money in the firm?
Okay, I'll explain about that. When the documents or money of a third person is deposited with the firm, misapplication of that money may render the firm liable. There are two situations, which is the first one is when one partner acting within the scope of his apparent authority receives the money from the third party and he misapplies it. And the second situation is when a firm in the course of its business receives the money or the document, and the money or the document misapplied by the partner, one or more partner in the firm, while it is in the custody of the firm. So the firm is liable to make good the loss.
I see. Thank you.
Welcome.
Anyway, guys, do you know what happened when one of the partners misused the trust property?
No.
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 The person entrusted with the trust property will be liable, but others are not.
I see.
Then, what happens if there is another partner who is assumed to know about the breach of trust? Will he also be liable?
Yes, the partner who actually knew about the breach will be liable for the improper employment of trust property.
Okay.
Guys, I'm thinking to retire at the age of 58. Can I?
About that, yeah, sure you can, but you still remain as a partner even though you are already retired.
Then if I remain as a partner, I still have a lot of works to do, right?
Not a lot, but you may advertise our business and you are still liable for the debts and obligations incurred by our firm.
Mm-hmm.
You may not use our firm's name and also solicit our clients. Just a reminder, if you still a partner and if anything happens, you can be sued by our clients, even though you are already retired. However, we can set an agreement with the consent from all the partners to discharge retiring partner from any existing liability.
What should I do if I don't want to be a partner anymore?
Don't worry about that because our company will give a notice that you are no longer a partner. So by that, you are free.
Ah, I see. Okay.
Anyway, guys, talking about retiring, I remember about the liability of person holding out.
What does holding out mean?
It means that if a person represents himself as a partner, whether by words or by action, due to that representation, he would be made liable as if he was a partner. So, like, let's say that decided to retire from our partnership, but then even after she retired, we still use the old document, like our old note paper that contain her name in it. Um, and she know about it. So she will be made liable if there's anything happen within the business transaction.
But why? I already retired.
Yes, you are, but because you know about the usage of the old note paper that contain your name in it, and you didn't know, and you didn't even say anything about it or even do anything about it, it means that you gave the consent to us to use your name in our partnership. That's why you will be made liable.
Well, what if I do not know anything?
If you don't know, if you do not know anything about the usage of your name, then you will not be liable because there are three conditions to be fulfilled to consider someone to be made liable. That's it.
Okay, I think that's enough for today's meeting. Thank you guys for joining the online meeting. I know it's hard to meet outside, so goodbye.
Thank
Thank you,
you.
Thank
everyone.
you.
Bye.
Bye.
Assalamualaikum. I'm Nurul Najihah Binti Jazlan. Today I'm going to explain in details about contractual liability. In the section 11 state that every partner in the firm is liable jointly with the other partner for all debts and obligation, and while he is incurred as a partner, and after his death, his estate is also severally liable in a due course of administration for such debts and obligation, so far as they remain unsatisfied, but subject to prior payment to his separate debts. Okay, which means that in the contractual liability, there is actually two things, which is jointly liability and also several liability. Okay, the first one is joint liability. The effect of provision that is that all partners is in a firm are jointly liable for all debts and obligations which are incurred while he or she is still a partner. Legal action can be taken against one or all the partners that involved to recover the debt. Or legal action can also be taken in the firm name, which means that all the partners will be liable in this thing. We can see in the case of Kendall versus Hamilton, K loaned her money to X and Y, but eventually X and Y could not pay the debts. So K took a legal action against both of them, and it causes them to become bankrupt and they could no longer pay for the debt. So after that, K knew about H. H is another partner of X and Y. So K wants to take a legal action against H, but the court held that it is a jointly liable, so which means that after K has taken a legal action against X and Y, K could not take another legal action towards him. Okay, the second one is several liability. When a partner dies, he is still liable for all the debts and obligation that arose while he's still a partner. His estate is severally liable for the debts. Liability is imposed on his estate depending on whether fund has settled all his separate debts. So after that, whatever is available from his remainder of the asset will be used to pay the whatever is still unpaid, even though it is not enough. So that's it for contractual liability. Bye.
Hi, my name is Dinie, Najwa, Binti, Zaher. I'm going to explain to you guys about a tortious liability. A partners may be liable for wrongs committed by their fellow partners independently of any contract. They may be liable for torts such as negligence, defamation, committed by their fellow partners. Section 12 of the Partnership Act states that whereby any wrongful act or any partner acting in the ordinary course of the business or with the authority of his co-partner, loss or injury is caused to any person not being in the same firm, the firm is liable to the same extent as the partner so acting or omitting to act. Liability for act done with the consent of the partners where a partner is given the full authority to do certain act on behalf of the firm is liable for his tort even if the authorized act is not carried out in the tortious manner. If the other partners did not give actual authority to commit torts, it is committed outside the scope of the partner's usual authority of the firm and the other partners will not be liable. Next is a criminal liability. Criminal liability are not jointly in a criminal cases. Criminal liability is a personal liability of a partner who commits a crime.
Assalamualaikum, I'm Nurul Sofia binti Rasid. Misapplication for money or property of third party arises in two cases: when money received by the partner and when money received by the firm. To render the firm liable when money received by the partner, there are two conditions. The partner who received the money or property must be within the scope of his apparent authority. Third party must deal with the partner as a partner and not in his personal capacity. To render the firm liable for misapplication when money received by the firm, there are two conditions too. The receipt by the firm must be in the ordinary course of the firm's business, and the misapplication must be made while the money or property is in the firm's custody.
Assalamualaikum warahmatullahi wabarakatuh and selamat sejahtera. My name is Najwa binti Yasir. Now I'm going to talk about liability for improper employment of trust property. Section 15 states that if a partner being a trustee improperly employs trust property in the business or on the account of the partnership, no other partner is liable for the trust property of the persons beneficially interested therein, provided as follows: this section shall not affect any liability incurred by any partner by reason of his having notice of a breach of trust, and nothing in this section shall prevent trust money from being followed or recovered from the firm if still in its possession or under its control. This section means that if a trust property has been entrusted to a partner as a trustee and it has been improperly used by a partner in the partnership business or for the partnership purposes, the other partners cannot be made liable unless they know of the breach of trust. For example, in the case ex parte Eaton, a father and his sons were partners in a business. The sons were trustees of a will. They had used the money for the purpose of the partnership business. When the firm went bankrupt, the court held that the money which has been misused cannot be recovered from the partnership property. That's all. Thank you.
Assalamualaikum. My name is Fatin Amira. So here I will talk about the liability of retiring partner. So in our video, One of the partners said that she wants to retire at the age of 58 years old. Under Section 19, subsection 2, state that a partner who has retired remains liable for the partnership debts and obligations incurred while he is a partner. However, Section 19, subsection 3 state that a retiring partner may be discharged from liability for debts and obligations incurred while he is a partner by way of novation, which is like an agreement between the retiring partner and also a partner. The retiring partner is still liable for the third parties as for the debts that incurred by the firm after he has left, as he is still a partner, unless he has given a notice that he is no longer a partner. Section 38, subsection 1 state that where a person deals with a firm after a change in its constitution, he is entitled to treat all the apparent members of the old partner as he still being a member of the firm until he has notice of the change. As the retiring partner don't want to be a partner anymore, the firm need to give notice about it that he is no longer a partner. There is another situation where the retirement of the partner has been advertising in public. He is still liable for the debts and obligation because there is no notice have been given that state he is no longer a partner. Okay, there is two types of notice. The first one, for those who have been dealing with the firm before the changes, for example, the old customer, an actual notice of retirement must be given under Section 38, subsection 1. The second one, for those who had no dealings with the firm before the change, for example, the future customer, a general notice in Federal Gazette, it depends on the location of the business, is sufficient as notice of the retirement. That's all for me. Thank you.
Hi guys! So in the meeting, I've already explained the meaning of holding out. It is referred by the virtue of Section 16 of the Partnership Act 1961, which states everyone who by words, spoken or written or by conduct represent himself or who knowingly suffers himself to be represented as a partner in particular firm is liable as a partner, and etc. And I also mentioned that there are 3 conditions that must be fulfilled. The rules is under Section 16, which is based on the doctrine of estoppel. The first one is there must be representation made by himself or other person that he is a partner. It can be made by words or acts, directly or indirectly. The second one is the third party relies on representation. It means that the third party believes the representation is true and acted upon it. Last but not least, as a consequence, credit is given to that firm. If all the condition is fulfilled, the person making the representation is stopped from denying the statement that had been made and is considered liable. That's it.